All right, let's get right into this one. Picture this, a massive government project, we're talking millions of dollars, set to deliver a service people really need. But then, right before it goes out for bidding, everything just stops. The whole thing looks like a total mess, a classic case of government failure.
So, what are we talking about here? A huge digital technology platform. The official documents, the terms of reference, or TOR, they go public. And almost instantly, experts from the private sector start raising red flags. They're saying the document is just filled with critical, show-stopping errors. The whole thing seemed like it was going to be a complete disaster before it even got off the ground.
And this is where the story gets really interesting. Because what if I told you that this apparent catastrophe, this last-minute discovery of huge flaws, what if that wasn't a failure? What if it was actually the system working exactly the way it's supposed to?
To really get why, we need to look at the evidence first. There were 3 massive problems that were found. One was technically impossible, another had unfair rules, and the last one was basically a legal time bomb. Any one of these could have sunk the entire project. So let's quickly meet the culprits.
First on the list, a major technical problem. The contract was asking for a piece of computer hardware that, well, it just doesn't exist. Seriously. None of the world's top manufacturers make it. It's like putting out a contract for a car, but demanding that it has to have square wheels. Just not going to happen.
The second big issue was in the rule book. Buried in the fine print were these clauses that, probably by accident, made it impossible for some of the best qualified companies out there to even submit an offer.
And number 3, this one was a ticking time bomb. The contract required so much personal, sensitive data from bidders that it was on a direct collision course with modern data privacy laws, like the Personal Data Protection Act, the PDPA.
So you've got an impossible spec, unfair rules, and a huge legal risk. It sounds like a total failure of planning, doesn't it? Well, here's the twist. Finding these flaws wasn't an accident. It was an expected, and you could even argue necessary, part of the whole process.
This is where we flip the whole thing on its head. Yeah, the initial reaction is bureaucratic failure, but the deeper truth, it's a safeguard. The entire process is designed to release a draft first, specifically so market experts, the people who actually build this stuff, can tear it apart and find these hidden problems. It's basically free public quality control.
Okay, so now that we know the system is supposed to catch these things, let's put on our detective hats. Let's really dig into the anatomy of these 3 errors. How in the world did they get into the contract in the first place, and why does it take an outsider to even spot them?
The first flaw really boils down to this one number, 30. The contract said that every single computing server, or node, had to have at least 30 high-performance GPUs inside it. Now, if you're not an engineer, that just sounds like a random big number. But if you are an engineer, that is a giant flashing red light.
And why is that? Because, simply put, it goes against the nature of the architecture. It's an engineering impossibility. It's kind of like trying to build a 100-story skyscraper on a foundation that was only ever designed for a 2-story house. The physics of it just don't work.
And check this out. This chart lays it all bare. The big guys, like NVIDIA and Dell, their standard systems have about 8 GPUs. The really high-end ones might have 10. 30? It's not a product anyone makes because it's just not technically viable. This is exactly the kind of super-specific industry knowledge that this public review process is designed to bring to light.
Now, the next 2 flaws, they didn't come from some technical mix-up. They came from something much, much more common. Boilerplate clauses. That standard copy and pasted legal text that gets dropped into contracts all the time. It saves time, sure, but man, can it create huge headaches if you're not careful.
Here's a perfect example. Imagine you're a company trying to bid on this. In one part of the contract, it says, just give us a list of your qualified staff. Simple enough. But then, deep in another section, a boilerplate clause demands certified signed copies of every single degree and every single employment contract for your entire team. It's confusing, it's a ton of work, and it's a conflict you'd only spot when you actually try to do the paperwork.
And this one's even more serious. Another standard clause asks for proof of Social Security payments for all staff. Seems totally reasonable, right? But here's the catch. Thai law actually exempts some government-related employees from that specific system. So without meaning to, this one little clause unfairly disqualified a whole bunch of perfectly good bidders. An internal team might easily miss that, but you can bet the companies it affected saw it right away.
And that brings us to the third flaw. Asking for signed copies of hundreds of employment contracts and degrees? That goes directly against modern privacy laws like the PDPA.
I mean, these laws are built on ideas like data minimization, meaning you only collect what is absolutely necessary. The contract's demands were excessive and created a huge legal risk for everyone involved.
Okay, so we've seen the flaws. They're bad. But, so what? What if the agency just plugged its ears, ignored all the feedback, and pushed ahead anyway? What were the real stakes here? Well, the short answer is total catastrophic failure. Ignoring these problems would have kicked off a chain reaction, a predictable domino effect. First, you have an unfair process. That leads to legal challenges from the companies that were shut out. Then, the whole project gets tied up in court, grinding to a halt for years. The end result? The public never gets the service, and over 100 million baht of taxpayer money is just gone. Wasted.
And that right there is why the decision to hit pause wasn't a failure. It was the only responsible thing to do. It was an act of good governance, plain and simple. It was about protecting the project and the public's money from a guaranteed disaster down the road.
This quote from the analysis just says it all perfectly. A small delay right now is nothing compared to the absolute catastrophe of moving forward with a broken plan. So this wasn't a setback, you see. It was risk prevention live in action.
And the best part? The fix was already built right into the law. The process is really straightforward. You take the expert feedback, you revise the contract, you republish the corrected version, and you give everyone a bit more time to submit. It's transparent, it's legal, and it makes sure everyone gets a fair shot.
So when you boil it all down, what's the big takeaway from this whole thing? It's a really powerful lesson that in these huge, important public projects, being obsessed with speed can be incredibly dangerous. Taking the time to listen, to check your work, and to change course when you need to, that's not weakness. It's a massive strength. Doing it right is always better than just doing it fast.
And that kind of leaves us with one final thought to chew on. We all complain about how slow the government can be sometimes. But when you see a case like this where a delay actually prevented a multi-million-dollar disaster, it really makes you stop and ask, what is the true cost of speed?